Just a quick disclaimer that this is a hypothetical situation. I am not qualified to give legal advice, and this advice should not be relied upon. Please seek the advice of legal and financial professionals rather than watching YouTube videos. This advice is to the partner of my law firm. The client has conducted business as a nanny for 1 year previous and is now looking to go into business with her partner. We will call the founding partner Partner A and the later entering partner Partner B. They wish to work identical jobs, individual of each other. However, the families will be paying into one central account which costs and pay come out of. Partner B will be taking out a personal loan to purchase his 50% share of the business. Once the loan is paid out, our client and her partner are looking to take on a management-only role with employees carrying out the nannying tasks for them. The client has expressly stated that she is not interested in discussing trusts. I've advised our client to enter into a partnership over a joint venture and a company. However, later the partnership should transition into a proprietary limited company on the completion of the loan. I will now explain my advice in detail on the best fit between a joint venture, partnership, or a company for the initial stages of the business. The basis for a partnership over a joint venture is that our clients will be working together to conduct business, not simply achieve a common goal or complete a standalone project. See the 1889 case of Ballantyne versus Raphael. The reasoning behind a partnership over a company structure is for pure simplicity. There is no need to set up a company at this early stage as there is no liabilities. It is advisable to focus on how a partnership works together before adding a more complicated structure. There is no dispute as to the existence of a partnership. However, the business must be defined as a partnership in order to follow the legislative pathway. Section 6, subsection 1, C Partnership Act, 1891 Queensland. A partnership that is not limited or incorporated does not bear its own legal entity, as it is not recognised under legislation, and therefore the legal entity falls back to the partners as individual material persons. It is because of this principle that the partners have unlimited liability. This is covered under Section 12, subsection 1 of the Partnership Act. There is scope for a limited liability partnership. However, it only applies in circumstances where there is at least one general partner and one or more limited partners. The general partner still carries unlimited liability. Under Section 60 of the Partnership Act, it gives the limitations of the limited partner, the first of which is that a limited partner cannot contribute to the management of a business. The limited liability partnership scheme does not fit these circumstances. It is aimed more at a partnership structure where there is a managing or working partner and there is a financial partner who has only contributed money and wishes to be protected to that extent. Partnerships like sole traders enjoy a higher threshold of privacy in that there is no need to register the business name unless wanting to carry on business under a name other than that of your own. This can be found in Section 81 of the Business Names Registration Act. However, the parties still have a fiduciary duty to each other and to the public through Part 2 and 3 of the Partnership Act, which includes the ability of one partner to bind the partnership, Section 8 of the Partnership Act. See also the 1860 case of Cox versus Hickman. There was no need to discuss maximum partner numbers, as there is no future plan to spread the partnership to anything beyond the situation that is now. The preliminary stages of the business. For the preliminary stages of the business, my final recommendation is to enter into a general partnership. Beyond this, the client wishes to expand the business once Partner B has paid off his debt. Partner A and Partner B wish to take on a management-only role with employees carrying out the nannying tasks. I've made the recommendation to expand the partnership to a private company. I've only briefly discussed this transition, as new, fresh advice will need to be obtained when the time comes to make the step from a partnership to a company. I've chosen this direction to advise on solely for limited liability. The client is advised that once the business has taken this step to employ staff, they will also be purchasing assets, such as cars and mobile phones. Section 124 of the Corporations Act provides that the legal capacity for a company. A company has the legal capacity and powers of an individual both in and outside this jurisdiction. Also see the 1897 case of Solomon and Solomon and Co. I gave a definition of a proprietary company based on Section 113 of the Corporations Act that a proprietary company must have no more than 50 non-employee shareholders. As per Section 700 to 741 of the Corporations Act, a proprietary limited company must not engage in fundraising from the public. And finally, under Section 1072G of the Corporations Act, a proprietary company must have provision in its constitution giving directors the discretion to refuse registration of a transfer of shares. I've explained limited liability of a company through which Section 124 of the Corporations Act provides by giving the company to be its own legal entity. I explained that this limited liability is not a complete protection. Both legislation and the courts have the power to lift this corporate veil, particularly by Section 588G through M, insolvent trading, and the court's discretion and Guildford Motor Co. Limited versus Horn for the improper use of a company's limited liability. See also Jones vs. Lippman. I gave the client a brief overview of what duties as promoters and directors they could expect. This was mainly quoted from the ASIC website. I didn't spend too much time researching this, as the reality of this was quite some time away. If the client wishes to transition to a company, I will spend a lot more time carefully explaining this. I drew particular attention to keeping records, as the client is personally liable for that. See the ASIC website, and also see Twycross vs. Grant 1877 and Tracy vs. Mandalay 1953 for duties as promoters. I concluded with a list from the ASIC website that generally denotes on how to stay out of trouble. This concludes my advice.